Of course, the one day I decide to go ahead and take off and relax, the judge decides to release his orders on everything. Hey guys, this is Jules with True Crime Reactions. Disclaimer. Everything stated in this video is my opinion and my opinion only, and just like everything else in these cases we discuss here on this channel, everything is alleged. Now, the last update we had was regarding the immediate family in the courtroom. Now, it looks like since that last video, Judge Hippler has released his orders regarding all of the motions that have been filed between both the state and the defense. We have a total of 5 filings. The order memorializing oral rulings on motions in limine, where there are several of these motions listed out in one single order, with all of them being decided on separately, but again, in one document. Then we have the one regarding the make and model of the suspect vehicle, the one regarding touch and contact DNA, where they were deciding on which verb, like the verbiage they were going to actually use in front of the jury. Then we have the one regarding witness identification by bushy eyebrows, the infamous phrase there, and then the one for neuropsychological and psychiatric evidence. I'm going to break those all down separately. This video is going to be the one regarding the oral rulings on motions in limine, where they have all of the motions that are not obviously listed separately all together in the one document. Let's go ahead and get those out the way. The first one is defendant's motion in limine regarding the inflammatory evidence. Defendant moves under IRE 403 to prevent the state from introducing testimony and evidence that is exceptionally inflammatory, arguing it is irrelevant and or unfairly prejudicial. The court finds this motion is premature. As with any potentially prejudicial evidence, the court must first consider whether it is relevant and material as to an issue of fact under IRE 401 before assessing whether its probative value is substantially outweighed by the danger of unfair prejudice. And then it cites State versus Wynn from 1992. At this point, defendant has not identified what specific evidence he wants kept out or otherwise defined exceptionally inflammatory. Issuing an order as requested by defendant would lack any substance. It would simply require the state to abide by evidentiary rules and prosecutorial responsibilities when presenting its case. The court finds this unnecessary and therefore denies the motion. However, this was a particularly horrific murder, and there will be exceptionally graphic depictions of the victims and crime scene. Prior to seeking the admission of this evidence, the state is required to provide copies to defendant. If the defendant believes the evidence is cumulative, unnecessary, or otherwise prejudicial, he can seek to take the matter up outside the presence of the jury. And that's basically the exact same thing we already heard at the motion hearing. The judge basically said, this is a murder case. There's going to be pictures of things that we have to show the jury in order to present the story of what actually happened to the victims, and also the state's theory. They have to explain all the things, and they have to show proof of things, i.e. receipts, meaning photos. We already know that that's how this goes down. The ones that are exceptionally graphic, and what I took by that was things where you could definitely see who it was, exactly what was done, the very specific wounds, things that were close up, things that were extremely graphic, not just maybe blood spatter on a wall, but obviously anything that actually had the victims in it that was exceptionally just horrible. I'm sure they're all horrible, but there are levels of things when it comes to these photographs. We all know it. When it comes to those types of things, there was supposed to be a conversation had off to the side. That's basically what was already said at the hearing. This just sort of seems sort of normal. And again, the court did state, at this point, you're not really telling me what it is that you think is inflammatory. So until you give me something specific, I can't really rule on anything. Like, I can't really just give this like vague ruling. I mean, honestly, it makes sense. So I guess if Anne wanted there to be a ruling that was more on their side, she should have given more specific examples, because they had time to turn in all of the things, you know what I mean? Like all the exhibits, all of the examples of things that they were talking about. But this makes it sound as if they haven't turned in any specifics regarding this at all. So yeah, it is what it is at this point. The next one is the defendant's motion in limine regarding the use of the term murder. Now, when it came to this one, I already said that this one obviously was going to have to happen because these people were murdered. These 4 college students were murdered, okay? There's no ifs, ands, or buts about that. That's the situation here. Now, to point at him directly and call him a murderer whenever we are just at trial and he has not been proven guilty, I understand that. But to just say, oh, you can't use the term of the reality here whatsoever, that was already way reaching. So for this one to go the way that it went, I'm not mad about it because that's what happened here. This is a murder trial. There's a reason why we're all here. And it's not because somebody stole a puppy. 4 lives were taken horribly, disgustingly. The term murder is very much necessary. And if we're going to throw a fit about the fact that YouTube makes us speak some sort of crazy, weird YouTubese type language instead of using real words, then we kind of have to disagree with this one, no matter how we feel about the evidence so far. Let's be for real. This one goes on to state, defendant seeks to prohibit the use of the words murder, murderer, murdered, murder weapon, and similar forms of the word murder as applied to defendant. Again, defendant seeks an order requiring the state to abide by the evidentiary rules, particularly the prohibition against argument outside of closing. This is unnecessary. The state acknowledges it would be improper to refer to defendant as the murderer other than stating what the allegations are and has no plans to do so or otherwise elicit similar testimony from its witnesses. Thus, the motion is denied as unnecessary, which I do agree with. Now, I know that when it comes to murder weapon, that one is still up in the air because we've never had them come out and claim that this K-bar that they've put so much weight on is the one and only weapon used in this scenario. And we have the defense coming out themselves and claiming that their experts are looking at all the evidence and saying 2 people, 2 weapon minimum. There's no way that this happened any other way. The next one is the defendant's motion in limine regarding the terms psychopath and sociopath. Now remember, in the hearing, Judge Hippler said himself that there was no proof that there was any diagnosis like that associated with Kohberger, so it shouldn't be said anyway because there's no proof that it exists. Therefore, it wouldn't be necessary. It shouldn't be said in the first place. Now, we've had this judge say something in court and then turn around and do the opposite on paper, so let's see what he did. Defendant moves to exclude any reference to the term psychopath or sociopath at trial, arguing it is unfairly prejudicial under IRE 403 and improper opinion testimony under IRE 702. The state does not intend to use these terms at trial, according to Xana anyway, or at least according to what they said at the motion hearing. Indeed, the terms are irrelevant given the lack of evidence defendant has been diagnosed with a personality disorder or similar mental illness. Their use would also be highly prejudicial. Thus, the state is not to use these terms or their equivalents at the guilt phase of trial. If, however, the state believes the door has been opened to allow the use of such terms, it shall raise the matter in advance outside the presence of the jury. The motion is granted. So basically he kept his word. He kept to the theme that he was speaking about in court. Now, if something happens, and I guess if they can prove something one way or another, and whatever is proven with that leads to those terms then being relevant, then I guess then if the state feels the need to, they can get permission from the judge and then get permission to use those terms. But until then, and until only then, they're not allowed to say anything regarding that, no matter how they feel. Facts over feelings, as it should be. Now, as you guys can see, it starts at the top with the state's motion regarding improper death penalty comments. We're going to skip that. We're going to do all of the defendant's motions first and then go back up to that one and start doing all of the states so that it's all separated correctly. Defendant's motion in limine regarding the unnoticed 404B evidence, which is supposed to only really be the traffic stop in Moscow from August 21st. So whenever they had the motion hearing argument with Eliza Massoth going back and forth with the judge, she was bringing up the DeSales homework paper, and that doesn't go with what the rules of 404 are, which are proof of some sort of other bad act. And the traffic stop is supposed to only be being admitted for like identification purposes, which I still find stupid and redundant because they have Washington State's DMV records. They have his Washington state license. They have his DMV records when he switched his plate. Like, they have all of the stuff from his own state where he was living and registered. So why do they even need the traffic stop video? I mean, I get what they're trying to claim here, but they have the exact same evidence already when it comes to proving who he is. And it's not like he's coming out saying, I'm not Bryan Kohberger. Defendant moves in limine to exclude any IRE 404B evidence that has not already been noticed by the state, which at this point is only defendant's pre-homicide traffic stop. By way of example of allegedly unnoticed 404B evidence, defendant notes that the state intends to present evidence of defendant's graduate paper regarding how to conduct a crime scene investigation and his Amazon purchase records, both of which defendant contends are subject to IRE 404B. And they're not, according to the actual definition of what that's for. As an initial matter, defendant appears to misapprehend the scope of IRE 404B. The rule provides that evidence of a crime, wrong, or other act is not admissible to prove a person's character in order to show that on a particular occasion, the person acted in accordance with the character. IRE 404B1. Defendant takes the position that other acts encompasses any other acts of any nature other than the crime at issue. The rule is not so broad. Its purpose is to govern the use of character evidence. It forbids the use of evidence to show a defendant's criminal propensity. And then it cites State versus Johnson from 2010 that also cites State versus Sheldon from 2008. If the evidence does not bear upon the defendant's character, it is not subject to IRE 404B. And then they reference State versus Whitaker from 2012 that also cited State versus Norton from 2011, and we have our first footnote. In essence, the rule's reach is prior crimes, wrongful conduct, or other prior acts of a nature from which a jury could conclude the person as a bad character. From which a jury could conclude the person as a bad character and is therefore predisposed to commit crimes that charged. Okay. This conduct is commonly described by Idaho courts as bad prior acts. While the rule is not limited to bad acts, it does not implicate acts that do not bear on a defendant's poor character, even if that act is also evidence of the defendant's motive, intent, identity, etc., which they've already came out and said this is only for identity purposes. This is not to show premeditation or planning or opportunity or any of those things. We've gone over that rule to try to figure out what they were really trying to do here. They have been very adamant, both verbally and on paper, that this is for identification purposes only. Nothing else. Defendant's Amazon purchases and his graduate paper discussing proper crime scene investigation techniques do not, standing alone, bear on his character or suggest he has a propensity to commit crimes, including those charged. And now we have a second footnote, and it says, even if this evidence could qualify as character evidence, because it does not, defendant has notice of the state's intent to rely on it. Yes, that's true too, because they've admitted the fact that they plan to. They have submitted it in their self-authenticating information. But all it proves is that he was learning how to solve a crime, not learning how to commit a crime, if you really want to get technical about it. Further, the court is unwilling at this point to preclude the state from filing a 404B notice in the future if it determines its evidence is encompassed by the rule. There are still 4 months until trial begins, well within the reasonably in advance of trial time frame required by the rule. The state acknowledges its notice obligations under the rule and intends to comply with the rule with regard of any proposed IRE 404B evidence. The timeliness of such future notice will be analyzed if and when such notice is given and objections can be advanced at that time. The motion is therefore denied. Which is honestly kind of strange too, because how are you denying a motion regarding something that you are also sort of claiming doesn't even fall under the rule of 404B? Wouldn't this honestly sort of be more of like null and void? I mean, I guess denying them trying to take out the traffic stop is maybe the whole denied portion of it. But again, I agree that the DeSales paper and the Amazon purchases, they're not bad acts in themselves that then show that somebody's behaviors can then escalate literally at all. They don't fall under that whatsoever. They're not a bad act anyway. Like literally regarding anything, purchasing something is not a bad act. It's not illegal if it's on Amazon. That is a legal platform used across the planet. Yeah, no, none of it. It seems more like this should be more of a null and void situation instead of a denial. That's just me. The next one is defendant's motions number 10 and 11. Number 10 is the improper expert testimony from David Middleman, and the number 11 is excluding the IGG. And remember, the state and the defense, for their very own reasons, are both wanting the IGG out. Both of them. They honestly agree on like the strangest shit. Both parties moved to exclude evidence of law enforcement's investigative genetic genealogy testing in this case, but for entirely different reasons. That's literally exactly what I just said. Given the parties' agreement is not present any IgG evidence, those reasons need not be discussed given the bottom line agreement, and the court grants the motion. The state has indicated it will present evidence through Detective Brent Payne. Who the frick is Brent Payne, Hippler? You don't even know the police officer's names even in this case. You're sitting here reading through thousands and thousands of documents. You've watched this man get on the stand and testify, and you don't even know his name, and your clerks of court don't even care that it's wrong. Like, we know that y'all are already going to be making him lie on the stand for us to all witness in real time, but you could at least get the man's name right. And let me just point out, this is now the second judge that has slipped up and basically said a name that a lot of people have a lot of questions about. We had Judge over in Moscow accidentally almost call Kohberger, and now we have this new judge saying Brent instead of Brett for Brent Kohberger. I already know this has probably stirred up quite a bit. The state will have Detective Brett Payne come out and say that the defendant's name was revealed to law enforcement through a tip. To avoid issues at trial, the court advises the parties to arrive at a mutual agreeable narrative, meaning get together and figure out the lie as a team. Go team! Parties are also directed to jointly craft a jury instruction advising the jurors to not concern themselves with the source and the nature of the tip. So they're going to get together and construct a lie, not only for Brett Payne to come out and actually regurgitate on the stand under oath, may he be struck down, okay, but also to tell the jury people, don't even ask questions. You're not allowed to have a brain. You're not allowed to ask the obvious. You gotta shut your face, is what they're gonna tell them. And if you haven't seen this video, go look at this video. I'll have a link for it down in the description box. The CW recently put out a complete narrative where they really do dissolve the IGG. They mention it in passing, and they talk about how there's like a family tree that was created, and then they jump from this so-say family tree that's still being worked on, and they literally state, there's no one specific that it's pointing to at that time, and then they jump straight into, oh, now they need trash from Pennsylvania. They've already put the blue-pilled narrative out there, completely fading away what the FBI did here. Before we even get to trial, they're already getting it into people's minds that none of this ever happened. But remember, there are articles all over the place from after those Indiana traffic stop body cams came out of the feds taking responsibility for that. Then they had to backtrack because they realized that them inserting themselves was going to cause even more of an issue. But we know damn well that the feds were the lead on this entire thing. They're the ones who actually found his name. They're the ones who had some specialists figure out the make and model of the car, who actually didn't really figure out a make and model of the car because there were 7 different makes and models, and they didn't have anything too definitive when it came to him making his mind up on which one they really needed to look for until they had the phone call from the FBI. They're also the ones who swabbed Bryan's cheek. They're also the ones who took the inventory from his parents' house. They're also the ones who did the forensic download of his phone. They're the ones who did his AT&T location information. They literally did all of it. And now they're wanting it to just fade away completely, like they had no involvement whatsoever. Their name is on everything. Even the original search warrants, before they even had Bryan's information, the information was being sent to the feds. The feds were filtering it and then giving Moscow whatever pieces they actually wanted them to have, along with the next step instructions. No one at MPD ever even had to really use their brain. They were told what to do every step of the way. Now, there was a footnote here, and it does state, if agreement cannot be reached, the parties are to submit to the court their proposed narratives prior to trial, and the court will decide how it will be presented. So if they can't come to an agreement on how the lie is going to be told, then they can submit their lies, and the best lie wins. This is reality. This is the American justice system. The next one is defendant's motion in limine regarding conditions as aggravator. Defendant moves to prevent the state from using defendant's diagnosis of autism spectrum disorder, or ASD, and the characteristics of his ASD as an aggravating factor at the penalty phase of trial. The state responds that it has no plans to use such evidence as an aggravating factor in light of Zant versus Stevens from 1983, but it will argue against and rebut defendant's diagnosis to the extent he relies upon it as a mitigating factor. And we have a fourth footnote that says, to the extent defendant introduces evidence of his ASD as a mitigating factor, the state is allowed to confront that evidence so that the jury can afford it at appropriate weight. It cannot, however, attach an aggravator label to it. Despite the state's concession, the court is concerned with the breadth of the defendant's motion. He is not only seeking to preclude the state from referencing his ASD diagnosis as an aggravator, but any symptom of his ASD. Given the broad nature of ASD symptoms, the court foresees an issue potentially arising at trial whereby the state makes reference to an action taken by defendant, and that defendant contends it is a symptom of his ASD. That evidence is not currently before the court. Thus, at this point, the court will preclude the state from arguing or presenting evidence of defendant's ASD diagnosis as an aggravator, but it is not in a position to rule on whether any particular evidence must be excluded on grounds that it evidences a symptom of defendant's ASD. The motion is therefore granted in part only. But what does it mean by this is not before the court? Evidence is not currently before the court. They have information about his diagnoses from doctors, and they are currently in the process of getting all of those things verified. Like, they've had reports and stuff, and other doctors working with the doctors that have done the diagnosis stuff on Bryan. Now, remember, they've not only come in and checked him out verbally and talked to him and interviewed him and watched how he moves and acts and all the things, but they also did physical brain mapping of his actual brain. So they have an actual report that was done by a program that read and mapped out his brain and the different portions of his brain that work certain ways or not. There's like percentages and different things on this report. And the thing about this also is that the defense, in their own opening statement, want to make the jury and the entire courtroom aware of his autism diagnosis. So they want it to be known, but they don't want it to be used in a certain way, which I do understand. And you just cannot trust what the state or anyone who's trying to follow a narrative is going to try to say without there being that context, because context is so, so important. Defendant's motion in limine regarding statistical analysis. Defendant moves in limine to exclude any misleading comments about the meaning of a likelihood ratio for DNA purposes. Specifically, defendant seeks to avoid attempts to define likelihood ratio through a comparison to the world population, and we have a sixth footnote that says, defendant's motion is directed toward the prosecutor's questioning of a lab analyst at the grand jury proceedings. We went through that document. There, the analyst testified that her DNA testing showed the profile developed from the knife sheath was 5.37 octillion times more than likely to be seen if defendant was the source than if unrelated individual randomly selected from the general population is the source. In an attempt to clarify this result, the prosecutor asked whether this meant that if there were 1.37 octillion people, that it would be that Bryan Kohberger was one out of that many octillion. The lab analyst explained why this comparison is not a proper way to view a likelihood ratio. The state agrees that this type of comparison is inappropriate. The court grants defendant's motion insofar as it applies to the question asked by the prosecutor at the grand jury proceedings, which both sides agree was not proper. However, the court will not dictate how the question is to be asked at trial. If defendant believes there is a similar misrepresentation as to the likelihood ratio at trial, he can object at that time. Meaning, if the state doesn't want an objection come trial, they better figure out a different way to word this too. Meaning, create another lie. That's all I keep hearing here. The next one, defendant's motion in limine regarding inconclusive data. Now, this would be the one about Maddie Mogen's fingernail clippings that had a mixture of DNA. This is the one where they basically put the information in at the grand jury to look good for Bryan because their testing was inconclusive. Now, at the end of the day, the testing's actually excluded when it comes to Bryan. We've gone through the document here on this channel. We've read the entire thing that ended up being dropped by the state with more proof that Bryan Kohberger is actually excluded. Again, the defense and the state used the exact same testing platforms and ended up coming up with the exact same excluded result. Now, the only reason why there's even been a huge issue with this inconclusive verbiage is because the Idaho State Police Lab had to create their own sort of like measurement ratio thing that they had to make for their own purposes because they were having issues with the ratios between a certain gauge, and they had to create something only for their lab. They had to create a resolution for a problem that only is in their own testing results, in their own laboratory. These are not protocols or measurements or anything else that anybody else follows, literally just this lab. So in reality, their results are not true results because those are very specific protocols that, again, are not followed anywhere else. So it's kind of strange to me that the state's choosing to use that verbiage that sort of does look like maybe it could, but it might not be. It's very much on the fence and not very clear cut the way this should be. It's like, they wanted to muddy it up. I mean, why wouldn't they? It makes it easier for them to lie if things are muddy and not clear and precise. So, of course, they didn't want to put, actually, he's excluded. No, they wanted to put the inconclusive possibility out there because they're assholes. Defendant moves to limit expert testimony about the Idaho State Police Forensic Lab's statistical analysis of a swab taken from the fingernail clippings of Maddie Mogen, which is item Q13.1. The testing revealed a likelihood ratio in the inconclusive range as to whether defendant was a potential contributor to the DNA mixture. During her grand jury testimony, the lab analyst, Jade Miller, testified that inconclusive meant she was unable to say one way or another whether or not defendant is included in the mixture. And that right there is exactly why they don't want this muddied up boo-boo in there. Defendant argues this is misleading language and that it allows for an inference that defendant might be included, which he asserts is inaccurate. Both sides actually assert that. Thank you. The state indicates it will not offer the results of Q13.1 as inculpatory evidence, which defendant agrees renders his motion moot. However, if the state changes course with regard to the evidence, it must first raise the matter with the court outside the presence of the jury so the anticipated testimony regarding the meaning of inconclusive can be discussed. At this time, however, the motion is denied as moot, which is pretty much how I sort of feel like that other one should have gone. But if the state is so willing to just not even bother with it for the actual trial, then what was the point of them even admitting it at the grand jury? Besides the whole let's just muddy things up thing. That's the only thing that I can think of. And remember what we were told. At least 6 people at that grand jury wanted more information because it wasn't enough. Whatever they do have, which obviously things are being picked away at. Up until trial, things have been being removed, deemed irrelevant, deemed unnecessary, taken off the evidence list. And if these exact same things were actually presented at the grand jury, and with the abundance of information they are claiming was included, still had questions, and it's being picked away at to where we're going to get a skeleton compared to what was actually there for the grand jury. How do they really think this is going to go? 6 people felt like it was already not enough. Next, we're going to move on to defendant's motion in limine regarding excluding Amazon click activity evidence at trial. Defendant moves to exclude any evidence of defendant's Amazon purchase history or click activity on grounds that it is out of context, incomplete, and unfairly prejudicial. This evidence will be presented by the state through Shane Cox and Michael Douglas. Michael Douglas is Special Agent Michael Douglas, not just regular schmegler, okay, Special Agent Fed, all right, who will testify simply to what the documentary evidence state, all of which was provided to defendant in discovery. Now we have the 7th footnote. Within this motion, defendant also seeks to exclude testimony by Shane Cox and Special Agent Michael Douglas on grounds that their expert exposures are insufficient. That will be addressed in a separate order regarding defendant's motion to exclude vague and undisclosed expert testimony. The evidence is highly relevant. A K-bar knife sheath was found lying next to the body of one of the deceased victims, all of whom were stabbed to death. Defendant's DNA was found on the knife sheath. Records from an Amazon account registered to defendant's name and email show that a purchase of a K-bar knife and sheath was made from an account approximately 8 months prior to the homicides. Click activity on the same account shows the customer also viewed pages associated with K-bar style knives at the time and, in the week following the purchase, viewed pages associated with the shipping progress of the knife and sheath. So, purchase a knife, check the tracking, pretty normal. The product was shipped to Bryan Kohberger at his family address in Pennsylvania. We knew that. After the homicides, activity from the same account showed the user navigated pages related to the deletion of account activity, and a week later viewed pages associated with a K-bar knife and sheath. Navigated pages related to the deletion of account activity, but did activity get deleted? Like, was he looking to see which buttons you would need to click in order to delete something off of your history, or was something actually deleted? And a week later viewed pages associated with a K-bar knife and sheath. Well, looking at something like that after the crime, so many people sort of did that whenever we were kind of told that they were stabbed to death. You know what I mean? Let me read this again. After the homicides, activity from the same account showed the user navigated pages related to the deletion of account activity, and a week later viewed pages associated with a K-bar knife and sheath. But how long after the homicides was this deletion activity? See, I understand what it's trying to tell me, but it's not telling me that something was physically deleted. It's just saying this person looked at the pages that would lead to doing that, but it's not stating that something was actually deleted. And this is another thing. Somebody who's supposed to be so versed in cloud-based forensics would damn well know that deleting something off of your own Amazon app where you can view your account information does not delete it from your actual factual account, that it could literally be found by anybody that works at Amazon, even if you delete it yourself. Somebody who wants to teach rural areas about cloud-based forensics and get them up to speed with the times would know that. And again, it doesn't say something was actually deleted. So this is, again, just sort of strange wording. And the time frame is still not very clear at all. I really wish it gave us more specifics. This evidence establishes a significant connection between defendant and a K-bar knife and sheath, not the A. Because again, through all of this, what are they not telling us? They're not telling us that the one that he looked at, clicked on, purchased, anything related to whatever this the frick is about, they're not saying it had the USMC signia on the sheath. That's all I'm waiting for. Just tell us that. In addition, there is no basis under IRE 403 to exclude the evidence, particularly given how probative it is. Defendant argues it is misleading and prejudicial because it paints an incomplete picture of the account activity. Well, actually, it says and incomplete, but we know that that's wrong. To this end, defendant provides the declaration of his expert, David Howell, The founder of a firm specializing in digital forensics and digital marketplace analytics. According to Mr. Howell, far more information must be reviewed in order to attribute specific activity to a specific person or otherwise render an opinion about user behavior with forensic certainty, including Amazon advertising logs, recommended algorithms, cross-device history, retargeting behavior, account personalization, and device IDs. Defendant is free to challenge this evidence through cross-examination and establish through Mr. Howell why more information is needed to reach the conclusion the defendant made the purchases or clicks. However, it is not a basis for exclusion. There is nothing inherently unfairly prejudicial or misleading about the evidence itself. It will be up to the jury to consider all the evidence and decide whether defendant was the clicker. Thus, the motion is denied. And there is an 8th footnote that says, defendant relies in part on IRE 106 to exclude the Amazon click evidence. However, that rule is not an exclusionary rule. 21A Federal Practice and Procedure with a June 2024 update discussing FRE 106. Rule 106 does not give the opponent the power to prevent the proponent from introducing an incomplete statement. It only gives him the power to require the statement be completed or to complete it himself. Nothing that's not considered complete should be admitted in the first place. Well, that seems to be it for the defendant's motions on this document. The next video will be about the state's motions that are being addressed in this exact same document, and then we will do the other documents that were filed regarding Judge Hippler's existing orders in separate videos. Tell me about how you guys are feeling with these so far down in the comments. If you like the way that I present this information and give my opinion, please don't forget to leave a like on the way out. Subscribe to the channel if you are not subscribed already. And please don't forget to make sure that that notification bell is set to all so you don't miss any of my rants, reviews, reactions, updates, or deep dives. See y'all.